We want to spend the next 15 minutes talking about the late Justice John Paul Stevens of the United States Supreme Court, who, as you know, passed away this summer at the age of 97 or 8?
99.
99. And of course, probably one of the highest profile authorship doubters ever, or certainly of the last 30 years. Want to share the stage here, and I asked Tom to nudge me because I want to be sure to have enough time for his very poignant remarks. I just want to talk about the logistics. We gave him the Oxfordian of the Year award in 2009. We gave him the Oxfordian of the Year award in 2009. It was easy to do because in April of 2009, the Wall Street Journal article that ran about Supreme Court justices being doubters or not doubters. So that galvanized things. It was an easy decision for what was then the two American organizations, the Shakespeare Fellowship and the Shakespeare Oxford Society, to give Stevens the award of Oxfordian of the Year in 2009. It was really a no-brainer that year. I think for some reason, because I was a lawyer and was president, I think at that time of the SF, I was delegated with the task of getting a hold of him. And so I thought, well, send him a letter. So I sent a letter to Justice Stevens at the United States Supreme Court, regular postal mail, sent it down probably in August of 2009. Didn't hear. So I decided, well, I better follow up on this. And so I thought, well, I'll give him a phone call. I hate making cold calls, let alone to the United States Supreme Court. So I got a hold of the switchboard. What is this in, could I have Justice Stevens' chambers? What is this in connection with? Blah, 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 blah. Please hold. So I held for what seemed like eternity. Finally, I got through to Stevens' chambers, and his secretary, I think Janice Harley, was on the phone. I explained what this was about. I said, did you get the letter? She said, yes, we just got it. Mail takes a long time to get through to us because of the post 9/11 stuff. Everything's screened for, anthrax and germs and viruses and all that kind of stuff. So they had just gotten it. And I explained, I said, well, we want to give him the award, and if Justice Stevens would like to come to our meeting in Houston that year, we'd be happy to do it then, but we understand he's busy. He's got some other job, doesn't he? And we can come down to Washington and present it to him in person. She said, okay, I will speak with the justice. We'll get back to you. Nothing happened. Finally, I think she called me back, and she said, be here November 12th at 2. They don't say, as I said in the newsletter, they don't say what dates are good for you guys. Supreme Court says, be here November 12th at 2. You be there November 12th at 2. So Tom and I agreed we would represent the Shakespeare Fellowship, and then two people from the Shakespeare Oxford Society, Michael Pisapia and Melissa Delorto, came down from New York representing the SOS. And so we got there. We're going to have lunch at Union Station, the four of us, and then walk over to the Supreme Court building. That was our plan. So I had a plaque made up in Newton, flew down that day. As I'm getting off the plane at BWI Airport, my glasses broke. Right in the middle. And I thought to myself, if I go to the U.S. Supreme Court building with a piece of adhesive tape here, it's not going to really be the best impression that the Shakespeare Oxford group can make. So I was getting a little panicky, but I got over to Union Station early. Fortunately, I found an eyeglass place, and they were able to pop my lenses into a new set of frames. So that problem got solved. So we had a nice lunch. We walked over to the Supreme Court building, got through the screening. We were directed to go to the marshal's office, and somebody from the marshal's office personally escorted us, outside the tourist areas into the regular working areas, down to Justice Stevens' office. Since he was the senior associate justice, in other words, next in line to the chief justice, he gets the second best office in the building. And so it faces the U.S. Capitol. It's a three-room suite. So we were ushered into the second room. The second room is where his secretary works and maybe a couple of other people. And there's a room to the right, which would be for his law clerks, I guess. And his office was to your left, facing the street. So the secretary took our coats, hung up our coats. And These are the two things I remember the most that struck me. I was fully expecting the secretary to knock on his door and say, "Mr. Justice Stevens, your guests are here. Shall I show them in?" Before she had a chance to do that, Justice Stevens himself walked out from his own office into the second office and greeted us personally himself. And that tells you what kind of person he was, especially so, and it meant a lot to me because my professional career has been working as a court administrator for an appellate court. I know judges extremely well, and I know how big their egos can get. Even at the state level, multiply that by what it must be like to be at the top court in the United States. So that really, really struck me and is something I'll always remember. And the other thing that also really struck me is once he took the four of us in, and he sat down with us for a good 25 minutes, very gracious, sitting around a coffee table in his own office, the five of us talking. And you can't help but look out the window, and his window directly across the street, unobstructed view, is the United States Capitol. And it is really just mind-blowing to think that somebody, that's what they look at every single day. He's got a closer view, I think, than most of the members of Congress do of the U.S. Capitol, and it's really something. So anyway, those were my impressions. And then I should say afterward, he had to excuse himself to go to a conference. They had arranged for a Supreme Court intern to give the four of us, who were all attorneys ourselves, a private tour of the Supreme Court building, and that was also very, very impressive. They took us into the courtroom, and because we were all members of the bar, we got to sit in front of the bar enclosure, not just in the public gallery where the tourists go. So it was really a great day, and I hope I haven't intruded on your time. No. Thanks, Tom.
Perfect. Thank you. Thank you, Alex. So what I'd like to do as my tribute to Justice Stevens is I want to present a response to James Shapiro's recent New Yorker article on Stevens and the authorship question. Shapiro's article, written a few weeks after Justice Stevens died, tells how Shapiro received a letter from Stevens in August 2011, after which the two men corresponded for 6 months about the authorship question. Shapiro's article is a revelation. Not so much about Stevens, who steadfastly insisted on focusing on the evidence, but about Shapiro, who asserted foregone conclusions while refusing to consider counter-evidence and showed none of the academic spirit that would open-mindedly welcome alternative solutions to his pet theories. During the course of their correspondence, Shapiro attempted to dissuade Stevens from the Oxfordian theory by arguing that J. Thomas Looney was anti-democratic and wanted Shakespeare to be an aristocrat because Looney wanted the world to return to a repressive, feudalistic society where everyone knew his or her place. Let's think about that for a minute. Shapiro claimed that Looney wanted Shakespeare to be an aristocrat because that would somehow bring back feudalism. How would it do that? If we discovered that Shakespeare had been a nobleman, would that mean that common folk would suddenly clamor to be serfs again under the thumb of the lord of the manor? If Looney really believed such a silly idea, he would indeed be Looney. But Shakespeare Identified, which Looney wrote to introduce the world to his theory, expresses no such hope. Instead, it carefully and methodically lays out the incongruities of the Stratfordian theory, presents a list of characteristics gleaned from the works of Shakespeare that Looney believed the real author must have had, and explains how, after an extensive search, Looney found that Oxford had all the characteristics he expected to find in Shakespeare, and no one else came close. If Shapiro believes that there is some flaw in Looney's method, he does not bother to identify it. Rather, he impugns Looney's motives for making the inquiry at all. If there is a dominant leitmotif that runs through Shapiro's article, it is the theme of conspiracy theory. Shapiro drops the name of almost every notorious one he can think of: anti-vaxxerism, moon landing skepticism, Pizzagate, birtherism. He never displays any qualms at slapping the conspiracy theorist label on Stevens and anyone else who doubts the Stratford man. But what is a conspiracy? Conspiracy is defined in the dictionary as a secret plan by a group to do something unlawful or harmful. History is full of such plans. What about the Elizabethan Babington conspiracy, which sought to overthrow Queen Elizabeth and place Mary Queen of Scots on the throne? Or the conspiracy to kill Julius Caesar or Abraham Lincoln? Is a secret plan to hide an author's name unlawful or harmful enough to qualify it as a conspiracy? The Elizabethan age has been called a golden age of pseudonyms, a time when almost every writer used a pen name at some time. To investigate whether a name printed on a play is the author's real name or a pseudonym is therefore not an indulgence in conspiracy theories, but an attempt to uncover the truth about an era in which people had good reasons for hiding their identities. Add to this Diana Price's research showing that for the Stratford man, William Shakespeare, unlike any other Elizabethan writer, there is no documented evidence from his lifetime indicating that anyone thought of him as a writer. The concept of a hidden author behind the Shakespeare mask thus becomes a reasonable hypothesis. Merely labeling it a conspiracy theory seems obtuse and terribly lacking in nuance. Indeed, the evidence for Stratford is incredibly thin. All of it is either posthumous or ambiguous or both. The first folio obliquely identifies Shakespeare as a writer, but why does the first document identifying him as such not come until 7 years after his death? Shapiro states there's not a shred of documentary evidence linking Oxford to Shakespeare's plays, only speculation and surmise, he says. Shapiro asks Stevens how he could confuse circumstantial evidence with documentary evidence. Shapiro seems to think that circumstantial evidence is somehow not really evidence at all. But in a court of law, most evidence is circumstantial, and most cases can be proved entirely with circumstantial evidence. Circumstantial evidence is often more reliable than direct evidence. Shapiro trusts documentary evidence, but fails to consider that documents can be mistaken or can be made to lie, just as people can be. To simply dismiss a whole class of evidence without carefully considering the reliability of each piece of it based on its provenance and the circumstances that surround it is to take an extremely simplistic approach to evidence. This leads Shapiro into trying to dissuade Stevens from his belief about what happened over 400 years ago when the works of Shakespeare were created by arguing about the motives of an early 20th century British schoolmaster and his anti-democratic ideas, and by lecturing Stevens about the need to shy away from conspiracy theories because such thinking might encourage others to believe that President Obama was not an American. These things have nothing to do with what happened 400 years ago. Stevens, the legal scholar, was right to reject such arguments as absolutely irrelevant. Instead, Stevens looked at the evidence, the 6 shaky signatures that suggested a man who could barely write his own name, the complete absence of books, and the dearth of tributes upon his death. What is most disappointing about Shapiro's article is that, like many traditional Stratfordians, he cannot admit that there is even the least room for doubt about authorship, and instead he engages in ad hominem attacks, calling skeptics conspiracy theorists. Whether Shapiro or Stevens is ultimately proved correct is not as important as the fact that Shapiro, who has threatened to flunk students who persist in raising the authorship question, did all he could to suppress critical thinking, while Stevens continued to ask questions and to follow the evidence wherever it led, no matter the consequences. I'd like to invite you to join us in a moment of silence for Justice Stevens. Thank you.
By the way, I just want to add that it was also, as Tom Regnier's very powerful tribute to Justice Stevens that he posted on the SOF website very promptly, within a day after Justice Stevens' passing. Tom's posting of that tribute led directly to our New Yorker magazine coverage. So again, thanks, Tom.